Now, Mrs. Jensen, it's your testimony on the cross-examination, the examination by Mr. Albee, that you and your husband were not getting your stories straight during the course of those two recorded conversations that the jury just heard?
Objection. I don't think there's anything about getting stories straight. The question is whether they're manufacturing any kind of false story.
Why don't you rephrase your question?
Well, you indicated on cross-examination that it was not your purpose to manufacture false evidence.
That's correct.
It was not your purpose to make sure that you testified in a manner which is consistent with Mr. Jensen's theory of the defense in this case.
That's correct.
Now, do you recall testifying at an earlier evidentiary hearing in this matter?
In July?
Yes.
Yes.
Now, you understood going into that hearing, you knew that your husband had lied to the police about the commencement of your...
What's the objection?
There's no evidence in this record, and she wasn't present for any conversation with police.
I'm going to let the prosecutor ask the question, but keep in mind that in order for the question to have significance when you go to deliberation, the evidence must have satisfied you that in fact the accused did lie to the police. Go ahead and ask the question.
Before that hearing back in July started, you knew that your husband had lied to the police about when your sexual relationship with him commenced, didn't you?
Yes.
You knew that he had told the police repeatedly that the sexual relationship between...
Well,
Pretty direct.
All right, sustained.
Well, Your Honor, by the way, I do believe that we've reached the point where I should be able to conduct a leading examination of this witness.
Close, but I'm going to say no.
Okay. You understand, well, did you understand at the commencement of that hearing that your husband had repeatedly told the police that your sexual relationship with him did not commence until after his wife's death?
Objection to repeatedly and what that means. And again, she's not present for any conversation.
Well, just so...
Objection's overruled. Answer the question, please.
Do you remember the question?
Not specifically.
I request it be read back.
You understood going into your examination that your husband had repeatedly lied to the police about when your sexual relationship had begun.
I think that's a pretty fair estimation, Judge, of what I'd said. Thank you.
I'm going to put in for both pays.
I'm not getting much.
Yes.
And yet you also remembered, at the time that hearing started, that Detective Ratsburg had already interviewed you at about the time your husband was arrested, correct?
I thought he was interviewing me after he had arrested him. I did not know that at the time that I was being interviewed, though.
Correct. And at the time that you were being interviewed by Detective Ratsburg, you'd not yet had an opportunity to speak with your husband.
Objection leading.
Well, I don't know. I haven't heard the whole question.
Well, when you were interviewed by Detective Ratsburg, could you state whether or not you'd had the opportunity to get your story straight with your husband on this particular point of when your sexual relationship with him commenced?
No.
So when you were being interviewed by Detective Ratsburg, you had not yet been alerted to the fact that your husband's story to the law enforcement authorities was that your relationship did not commence until after Julie had died.
Objection assumes facts, not in evidence. This witness isn't in position to characterize whatever her husband had to say to Detective Ratsburg.
Overruled. Did you answer the question?
No, I'm not following.
I'm sorry if I'm being unclear. I'll try to put it differently. You do recall giving a statement to Detective Ratsburg.
Yes.
You do recall the statement to Detective Ratsburg occurred on or about the same day that your husband, Mark Jensen, was arrested.
Yes.
And Your Honor, I request that this document be marked as an exhibit. I show you this document that's been marked as State's Exhibit 164, and I ask you to identify that document.
This is a statement that Ratsburg wrote out for me when he interviewed me.
And that document is, it's dated what?
3/20/2002.
Thank you. And at the time that you were being interviewed by Detective Ratsburg, you knew that this related to an investigation into the death of Julie Jensen?
Yes.
And in that statement, you conceded, quote, "We first had sexual contact in October."
There's been no inconsistency.
It's not being offered, Your Honor, for that purpose. It's being offered for a different purpose.
Well, I don't know what purpose it is, so I can't.
Do you want me to tell you what purpose it is?
No, why don't you just start over?
So here before this hearing that occurred in July of this past year, you knew the police had this statement where you admitted to having a sexual relationship that commenced in October-November 1998, correct?
Yes.
And you knew that you'd indicated that it occurred in Appleton, Wisconsin, correct?
Yes.
And you also knew before this hearing that Mr. Jensen had lied to the police and said it didn't commence at all at that time, correct?
Yes.
So at that time that you were testifying in this hearing in July of this past year, you might have had a reason to want to minimize the differences between your testimony, the testimony that you were going to have to give because of this statement, and the evidence that was going to be presented where your husband had flat out denied the existence of a sexual relationship before Julie's death. Do you understand that question?
Was it a question? So far, you were just explaining.
I didn't hear what the witness said.
I said I didn't
Was it a
perceive it as a question. I thought he was explaining something or.
Start over.
So you knew at the beginning of this hearing, before you'd taken the witness stand,
The one in July.
yes,
Okay.
that your husband, and thank you for that correction, you knew before the commencement of the hearing in July of 2007 that your husband had denied the existence of a sexual relationship between the two of you before Julie's death, correct?
Yes.
And you also knew that there was this statement where you basically admitted only to the fact that the sexual relationship had commenced before Julie's death, correct?
Yes.
And then at that point, you were asked, in fact, I asked you, a series of questions about the extent of your sexual relations between Mark Jensen and yourself preceding Julie's death, correct?
Yes.
And you repeatedly denied that there were any sexual relations beyond that first one. You said it had commenced, but then you denied there were any further sexual relationships after that, correct?
Correct.
And I started examining you using non-leading questions about all these emails, which clearly indicated the existence of some kind of a sexual relationship. You remember that? And then you asked,
Judge, there's an objection, and
What's the objection?
the objection is it's continuing to be leading when there's no showing that that's appropriate with this witness, and Mr. Jamboy's characterization of his own questions at the time, and the witness doesn't have them to see them. Both those grounds.
Overruled on the first ground, sustained on the second.
Your Honor, the witness agreed with my description.
I understand, but well, I'll say this. The alternative, of course, is he'll have to go chapter and verse.
Which is exactly what I intend to do then. Once I find it.
Well, do you want the objection?
That's fine. We have an answer, but I do object to continued leading questions.
Are you withdrawing the?
Withdraw that objection.
All right, and I'm going to permit the leading questions from this point.
I'd request the last question and answer be read back.
I object. It was.
I either don't remember it or didn't hear it.
And that's the problem I have as well.
Question, I examined you using non-leading questions about all these emails, which clearly indicated the existence of some kind of a sexual relationship. Do you remember that? Answer, yes.
And by the way, just to make one correction, you referred to your examination at the time of that hearing as a cross-examination, and I think it was actually a direct, was it not?
I thought I corrected myself on that, Your Honor. If I hadn't, I intended to. It was a direct examination. Am I correct? Do you know the difference between a cross-examination and a direct examination? I'm asking you.
I have a general idea of it.
And at the time that I was asking you these questions, at the time of this forfeiture hearing, or this earlier evidentiary hearing, I was using non-leading questions, right?
I wouldn't know the difference between a leading and a non-leading question.
But in response to the questions that I was putting to you, questions that were clearly directed at whether the existence of a sexual relationship between you and Mark Jensen, you were denying that there was any sexual relationship between you and Mark Jensen between the point where you had the first sexual encounter and the time, sometime after Julie Jensen's death, correct?
Correct.
And then we took a break, correct?
Correct.
And during the course of the break, you consulted with your attorney who'd been present during the course of this examination, correct?
Yes, I did.
And then after the break, you came back and you acknowledged that in fact you'd had numerous sexual intercourse with Mr. Jensen on numerous occasions
No, go ahead.
between the time that it commenced and the time that Julie Jensen died, correct?
Objection to the phrasing numerous, vague.
Well, again, you'll have to go to chapter, question and answer.
Do you understand the question, ma'am?
Well, the question was objected to, and the court said, sustained, and you'll have to go to the
Let's just do it this way then.
which were asked.
Do you recall testifying at an evidentiary hearing on July 31st, 2007 in the case of State of Wisconsin versus Mark D. Jensen?
Yes.
And do you recall being asked and directing court and counsel's attention to the bottom page 7 of the July 31st, 2007 transcript? Do you recall being asked the following question, this is line 22. So, Mrs. Jensen, when was the first time that you met Mark Jensen? Answer, I think it was April 1998. You gave that, I asked you that question, you gave that answer?
Judge, there's nothing inconsistent with that testimony to anything that's been testified to today.
Well, it's an alternative to the objection, to the form of the question which he was asking before.
I respectfully disagree, Your Honor. My objection was to his phrasing of numerous, which is a vague terminology, and I didn't think that was appropriate to say numerous and expect a witness to interpret numerous.
Well, in that case, if that was your objection, then I'm going to overrule it.
So you recall being asked that question and giving that answer?
Yes.
No. Why don't you go back to your question about numerous?
Well, I like this one better, Judge.
All right, go ahead. Let's see what happens.
And do you recall being asked a question, and where was that you met him? And providing the following answer. Answer, it was at the Stifel Nicholas office in St. Louis.
Judge, this is not inconsistent.
I agree, it's not inconsistent. It's not being offered because it's inconsistent.
Then there's no purpose in reading it.
That is hearsay.
No, Your Honor, it is, I'm laying the groundwork for the point where she starts improperly and incorrectly and falsely.
Objection.
Go back to the question earlier.
Your Honor, are you instructing me to not ask this witness any questions regarding this previous testimony?
No.
Okay, well, that's what I want to do.
Not yet.
Oh, you want me to do it? You don't want me to do it yet?
A prior statement, even a sworn prior statement, is hearsay, unless there's an exception. Let's not get into that right now. Ask the question which started all of this.
Okay. So you testified during the course of that forfeiture hearing that you had not had sexual relations with Mark Jensen between October of 1998 and sometime after Julie Jensen's death, correct?
Correct.
And that was testimony that was at least more marginally consistent with Mark Jensen's misrepresentations to the police, and still being consistent with your earlier admission to the police, correct?
I guess, yes.
And then you were asked question after question after question about the extent of your prior sexual relations with Mark Jensen, and you consistently denied that there had been any sexual relations between you and Mark Jensen between October 1998 and sometime after Julie Jensen's death. Do you remember that?
Yes.
And it was only after we'd taken a break and you'd had an opportunity to consult with your lawyer that you then chose to correct yourself on that point.
Yes.
Now, during the discussions with your lawyer, did he explain to you the ramifications of giving false testimony in a murder case?
No.
Just a minute. Objection. Just a minute. Take a look at Chapter 905.
Yes, Your Honor, I'm looking at it. I'm looking at 905.
Well, and you're asking about something that I think is covered by that chapter?
Maybe so, Your Honor, but...
Well, and no, and then look at section.
Is there something you want me to do, Judge?
Well, I'm trying to find it. It isn't where I thought it would be. You know the status.
Do you think 90513, Your Honor? Or actually, I bet you're thinking of...
Subsection 2 of that statute, yes, sir. Thank you.
And 90513 subsection 2?
Yes.
Well, Your Honor, why don't we do you have the transcript in front of you?
I know I don't. I was trying to locate it. What was the date again?
July 31st, Your Honor.
Yeah. Page 7, did you say?
Well, it's the part that I want you to go to. I'll get to it in just a second here. Let me find it. I want to get to the part where it occurred right after the break.
It's page 32.
Page what?
32.
Who did you say?
32. Page 32.
And I would direct the court's attention to line 14.
All right, go ahead.
Well, I object. That's insufficient to establish the basis under 905-13.
Well, I'm going to take this up outside the presence of the jury, Your Honor.
No,
if necessary.
because I'm going to allow it. Go ahead.
Okay. Well, in that case, I don't want to take it up outside the presence.
But I will say this, let's make sure that we limit the scope.
So, I guess I'm going to start at the beginning of these questions that occurred in July of 2007. Do you recall being asked, and I'm page 8, line 15.
And Judge, I object based on the fact that he's asked a number of questions summarizing this, and now it would be inappropriate to go to specifics. We wouldn't allow specifics and then ask him to do overarching questions.
Well, it isn't really offered for purposes of the type of impeachment we ordinarily contemplate. I'm going to overrule your objection.
So page 8, line 15. Do you recall being asked the following question and giving the following answer? Question, and at what point did you start having sexual relations with Mark Jensen? Answer, we had our first sexual encounter in October, I believe, of 1998. Question, early October or late October? Answer, I don't recall the date. Question, where were you? Answer, Appleton. Question, so it was when you were opening the Appleton office? Answer, yes. Then skipping down to line 5 on page 9. Question, then how often would you have sexual relations with Mark Jensen thereafter? Answer, I don't recall having sexual relations with him again until after Julie died. Question, you never had sexual relations with Mark Jensen again until after Julie died? Answer, that I can recall, yes. Question, do you recall giving a statement to Detective Ratsburg in 2002? Answer, yes. Do you recall telling Detective Ratsburg we had romantic relationships since October/November 1998? Answer, yes. Now is your testimony, now that you had one sexual encounter with Mark Jensen in October of 1998, you didn't have sexual relationship with him again after that date? Answer, yes. Until after Julie's death? Answer, yes, that I can recall, yes. Question, at some point during the course of your relationship...
That's beyond the scope of what we're talking about.
Yes, I think so.
Okay. Get to that later. Let's see.
What comment?
I'm sorry, Your Honor, I was just... Line 20, page 20, line 11. Do you recall being asked the following question and giving the following answer? Question, now it's your testimony that you had sexual relations with Mark Jensen in Appleton in early October of 1998, correct? Answer, yes. And it's your testimony now that you never had sexual relationships with him again until after Julie's death? Answer, yes. Then line 20, page 21, line 2. Question, now you saw Mark on several occasions between the beginning of October 1998 and December 3rd, 1998, didn't you?
Objection.
Answer.
These aren't inconsistent statements.
Well,
I understand that.
Objection was
Answer, yes, I did. Question, were there times that he saw you and you saw him and you two were at a hotel? Answer, yes. Question, in Chicago, for example? Answer, yes. Question, in St. Louis, for example? Answer, yes. Question, but it's your...
Just hold on a second.
Okay.
This next question is...
Yeah, I won't ask that question. I saw that later, it was sustained, so I'm not going to ask that question, Your Honor.
All right, go ahead now.
Oh, actually, the last question was then read back, so I am going to ask that question. If you'll direct the court and counsel's attention to page 24, at the top of the page, you'll see that that question was read back.
Go ahead.
Well, that's the question at page 22.
It is.
13. Well,
Top of page 22, line 3. When Mr. Jensen was staying in Chicago at a Stifel Nicholas event, were you also in Chicago at the same hotel, the Stifel?
these are not inconsistent. She didn't testify any differently during her direct examination today. She's already testified.
Well, I think at this point, they're not being offered to prove the truth of the matter asserted. They're being offered for a different purpose.
There's no proper purpose for introducing these hearsay past
Well,
statements.
I don't agree with you. Go ahead.
Question. Again, page 22, line 3. When Mr. Jensen was staying in Chicago at a Stifel Nicholas event, were you also in Chicago at the same hotel, the Stifel Nicholas event? Answer, I'm not sure. Answer, I don't recall. I do not recall a Stifel event. Question, okay, so you were in Chicago? Answer, yes. Question, and stayed at a hotel in Chicago? Answer, yes. Question, and Mark Jensen stayed at a hotel in Chicago? Answer, yes. Question, and you stayed at that same hotel in Chicago? Answer, yes. Now, did you bring Mark Greenman with you? Answer, no. Question, he was your fiancé at the time? Answer, I don't remember the dates. I'm not sure.
Continuing objection, Judge. This is all hearsay, and it's all been covered on direct, and she answered these questions.
Overruled.
Question, well, this is before Julie's death, correct? Answer, yes. And it was after you'd met Mark Jensen? Answer, yes. Question, so at the time that you were at the same hotel in Chicago as Mr. Jensen, were you either Mark Greenman's fiancé or his wife, one or the other? Answer, yes. Question, and at this juncture, it's your testimony. You don't remember if at the time you were at the hotel, you were his fiancé or you were his wife, but you were one of the two things? Answer, yes. Question, and Mr. Greenman was not with you? Answer, correct. Question, and Mrs. Jensen was not with Mark Jensen, is that correct? Answer, yes.
I continued to object. This was all testified on direct. She testified to these things already.
This is for a different purpose. Go ahead.
Question, and you're saying you don't think it was a Stifel affair that you were there for? Answer, I don't remember what we were there for. Question, but it's your testimony that you did not have sexual relations with Mark Jensen at that hotel? Answer, that's correct. Question, now you and he emailed each other repeatedly.
No. I think you're getting off the topic. Well, all right, go ahead.
Now, you and he emailed each other repeatedly between the beginning of September 1998 right up to the time of Julie's death. Is that true? Answer, yes. And these emails would frequently conclude with abbreviations IMY, IWY, IDLY. Is that true?
Objection.
Answer.
Objection, Judge. This is not on the topic, as the court just noted.
No, I looked ahead a little bit, and I think it becomes clear that it is, so the objection's overruled. I'll tell you this, though, Mr. Chambois. It astonishes me, as qualified as the reporter is, and I can attest to that. I've seen the excellence of her work.
Am I going too fast?
But you're taxing her, I think. Am I right or wrong?
Madam Court Reporter, am I going too fast for you?
You're not going too fast.
I'll slow it down.
Too fast. It's just a question of you're taxing her. As I said, go ahead.
And Your Honor, I regret that is my reputation among the court reporters in Kenosha County, and I apologize to this court reporter. Question, and these emails would frequently conclude with the abbreviations IMY, IWY, IDLY. Is that true? Answer, yes. Question, and IMY means? Answer, I miss you. And IWY means? Answer, I want you. And IDLY means? Answer, I do love you. Question. So you were emailing him repeatedly between the beginning of September and right up to the time of Julie's death. I miss you. I want you. I do love you. Correct? Answer. Answer, yes. Question. And he was doing the same thing with you. Correct? Answer, yes. Question. And it's your testimony that notwithstanding those email communications, notwithstanding that, you only had sexual relations with him one time in the beginning of October 1998. Answer, yes. Now, I will ask you to remember...
Objection, this was objectionable last time, and it's objectionable this time.
Well, in just a second.
Shortly after this exchange, Your Honor, there's a break.
I understand. I'm just trying to see the objection actually at that time was sustained, but,
Appropriately so, Judge.
well, it may have been appropriate under those circumstances, perhaps not in this. Just hold on a second. Yeah, skip over that section. Down to-
Yes, Your Honor. Page 26, line 24. Question. Now I'm going to ask you to take a look at the television screen up there to your right, to my left. Can you see it okay?
Is there anything of value?
Well, yes, Your Honor, because it was only after we started going through this.
Just, I'm asking about the particular material in the transcript, whether there is anything of value up to the time after the break.
Okay, I'll let me take a look at that, Your Honor. Your Honor, why don't I'll withdraw that question, I'll put it to the witness this way. Now you recall then at that point, Mrs. Jensen, there was a stack of emails that we were going to go through, is that correct?
Correct.
Objection, no emails were presented before the break.
Okay.
Okay, then I'll go through it line by line.
No.
At the very least, Your Honor, let's go at the top of page 27, line 3. I propose to submit these questions.
He asked the question, and then it had to be done later because it wasn't, the material wasn't available.
Well, the question is whether the witness was alert.
The point is not so much what was available, but that there was available for display some of the emails.
A stack of emails that this witness was going to be asked about.
Mr. Jamboys is not allowed to testify in this case, and it's improper for him to do so.
Well, we're trying to reconstruct the factual setting. At the time, is it correct? And I'll direct this to the witness. At the time, prior to the break, was there discussion about the fact that that there were a series of emails which were about to be presented?
I believe so.
Some of the emails that have been testified to at the trial today or yesterday?
But that's what we talked about then, yes, after the break, yes. I don't know
But
what...
the fact is that the state was going to examine you about
The emails.
emails.
Yes.
All right, go ahead.
And then in order to have them marked as exhibits, we took a break, correct?
It's not important. Just, we took a break. And then there was a break, is that true?
Yes.
Go ahead.
And then when we came back from the break, there were questions about your previous marriage to Mark Greenman. Do you remember that?
No, not specifically.
Okay. Do you recall being asked the following question, page 29?
Let's get to the material that pertains to this issue, Mr. Jeffers.
Well, but I want the witness to understand where she's at, Your Honor, so I was going to refresh her recollection with this following question and answer.
Well, the court has said he can't at the moment, so he shouldn't start reading it unless the
I would
court changes
suggest you
his
start
mind.
at page 31, line 21.
Very well. I'll follow the court's recommendation. Page 31, line 21. Do you recall being asked the following question and giving the following answer? Question, but you arrived on Thursday in Appleton, correct? Answer, Thursday evening, yes. Question, and then when did Mark Jensen arrive? Answer, I don't remember. Sometime Friday, maybe. Question, and that's the time when you commenced having sexual relations with Mark Jensen? Answer, Friday night, I suppose so. Question, well, that was 3 or 4 days after you got back from your honeymoon? Answer, yeah. Question, but it's your testimony that you had sexual relations with Mark Jensen that one time and never again until after you married or until after Julie had died? Answer, yes. I spoke with my attorney at the break, and I needed to clarify that I did not have sexual intercourse with him, but we did have oral sex. Question, you did what? Answer, we did not have sexual intercourse, but we did have oral sex. My attorney suggested I relay that.
Objection to anything further?
Question, so sort of a Clintonian distinction here about you had sex but not sexual relations. Answer, yes, but I wanted to clear that up. If that's what sexual relations includes, then there it is. Do you recall those questions and answers being posed to you, those questions being posed to you and those answers being given by you?
Yes.
So it was after you spoke with your attorney that you decided to own up to the fact that you've been having sexual relations with Mark Jensen on a regular basis between October of 1998 and sometime up to and after Julie Jensen's death. Isn't that true?
Objection, Mr. Jamboy's never defined sexual relations during the course of his examination in that case.
So ruled.
Isn't that true?
At the break, I went and spoke to my attorney and said, I feel like I'm misrepresenting it here. This is what actually happened. We didn't have sexual intercourse. We had oral sex. And when you first started asking me the questions, that's what I interpreted as. But as you got into it more, I realized I was not answering as clearly as possible. And at the break, I decided to confer with my attorney to see what he suggested.
So you were talking with your lawyer about the meaning of sexual relations, not
Yes.
the meaning of perjury.
Yes.
Objection, it's argumentative. Overruled.
Now, you've had another opportunity to consult with your attorney over the lunch hour, correct?
Well, I had the opportunity, yes.
Anything you want to change about your testimony concerning when this conversation occurred about your previous sexual partners?
Objection. It's argumentative, and well.
Overruled.
No.
You understand that the question of when you had this conversation with Mark Jensen regarding your previous sexual partners is a material issue, a material fact in this case?
Objection to the witness.
Overruled.
Were you finished with your question?
Did you hear the question?
I didn't hear the whole question.
I request the question be read back.
Was there a whole question?
Yes, there was.
Question, you understand that the question of when you had this conversation with Mark Jensen regarding your previous sexual partners is a material issue, a material fact in this case?
I didn't realize it was.
Well, now you realize it is?
Now I realize it is.
And nonetheless, it's your testimony here today, under oath, that the first time you spoke with Mark Jensen regarding your previous sexual partners was sometime in 1999?
That's what I remember, yes.
That's what you remember?
Yes.
Now are you telling us that possibly your memory could be mistaken?
It's been 9 years, yes. Possibly it could be mistaken.
So there is a possibility that you had this conversation with Mark Jensen in 1998.
I guess it's possible.
Well, Now, at the time that you were talking with Mark Jensen about your previous sexual partners, he had you describe each one by name, correct?
Yes.
He had you describe where you met that person, correct?
Objection, motion in limine.
Well, this is why motions in limine can cause problems, because situations change and the objection is overruled.
I guess he asked that question on some, yeah. I don't know if he did all.
Well, he had you list them in order from beginning to end, didn't he?
No.
Your Honor, where is that? I think those documents have been marked as exhibits.
Object 90404B, 90403, 90402. Due process.
It's time for your break. This is why resolution of issues by pretrial motion is overdone particularly in criminal cases, because the situation can change and the picture that presents itself to the court now is very different from what existed before the trial.
I will say that this is exactly why we should have more motions in limine, Your Honor. I have no idea why he was allowed to read all the things. He was allowed. All right. Let me go back to the beginning with my objections here. One, I objected at sidebar at the beginning of this questioning to Mr. Jamboy's taking over the cross-examination. I think it's improper. The general rule is that one attorney shall handle each witness.
Where's that rule?
I'm saying
do that at the sidebar. Where's the rule?
And in the 10 seconds notice I had, and up to now, I don't know because I haven't done any research. But it's been a rule.
That's a convention.
It is a convention, and it's been
not a rule.
Judge, I'm going to call it a rule. If the court wants to call it a convention, fine. I'm calling it a rule. I believe it to be a rule. I know it's been this court's convention throughout the proceedings.
I have never permitted lawyers to double, although they were doing it earlier, double teaming, where one was objecting while another one was during the same examination. That I don't permit. And I'll tell you why I don't permit it, because the reporters have asked me that it not be permitted. And it can be confusing at times too. Well, there is no rule with which I'm familiar that one lawyer has to handle the direct and the redirect. And I don't think that the court should be interfering with the presentation of cases. The explanation, the reasoning you gave me at the sidebar, as I understood it, and you can correct me if I'm wrong, was that it puts the witness at a disadvantage. Now, I don't know what that means. Well, a witness is not supposed to have an advantage or a disadvantage. The witness is supposed to tell the truth.
And that's right. But the court just said it. The witness is not supposed to have an advantage or a disadvantage. Here's the thing. I think when a party chooses which party to handle the questioning, they make a tactical decision. I think to shift gears on the witness and to play a Mutt and Jeff game essentially in front of the jury. I'm just saying, I'm registering my objection that it's improper.
I've never seen that in print.
Okay, I mean, that's my objection. I'm making my record. Then, Mrs. Jensen,
No.
Mrs. Jensen, on direct examination, answered virtually every question asked of her the same way as she did in the transcript in July that Mr. Jamboy's read at length.
Offered for impeachment. It was being offered by the state, as I understood it, for a different purpose altogether.
But what purpose?
Well,
It has to be inconsistent in order for it to be legitimate for that purpose.
There's 24 different exceptions to the hearsay rule.
I'd like to hear which one it is then.
You go ahead and because you're going to say it in less words than I am.
I was introducing it because she was lying then and she was lying here, and she changed her testimony then and she just changed her testimony here. And the purpose of the direct, and now it's an adverse, I would say it's a cross-examination of this witness, is to ferret out in front of the jury the truth. And the only way to get the truth out of this witness is to go after her.
I thought you were going to succinctly state it so that I could embrace it, and obviously you're not going to. I think that the reason it was allowed was
motive evidence. This witness has bias and motive to lie in court. And
That part I agree with.
No, her prior testimony where she said, I was at that hotel with him, I was at that hotel with him, I was at that hotel with him. All that stuff is consistent with what she testified on direct, and it wasn't motive today. He could ask her the same questions. It wasn't inconsistent, and so he could not use the transcript to have it repeated. And by insinuation, he made it seem to the jury like she had given different answers, and she did not.
No. You're thinking too much like a lawyer, Mr. Albee. The reason we don't allow the transcript is because the transcript's hearsay. And the only way it can come in is if it falls under one of the exceptions to the hearsay rule.
We don't have one.
Yes, we do.
What is it?
It's not being offered to prove the truth of the matter asserted. It's being offered to prove that the witness has been suborned by the defendant and that she's tailored her testimony to conform to her instructions. Now, I'm not saying that that's the fact. I'm saying that's what he's entitled to argue to the jury.
And Your Honor,
There's not one iota of evidence any time before here that anything like that happened. And what he did is he read back answers that she gave consistently then and now. And that's not right, because he's insinuating.
The only reason that the statement, you're saying, well, they can't come in because they're not inconsistent. But the only reason that anything doesn't come in a transcript is that it's hearsay. And if there's a hearsay exception, or if it isn't definitionally hearsay because it's not being offered to prove the truth of the matter asserted, then it can come in.
Well,
so I don't recognize your objection as being well.
I believe it to have been offered for the truth. Next, I have an objection that I posed because this witness was not an adverse witness. She never expressed any hostility at all to this examiner, and then he was allowed to bully her through a cross-examination.
Except that she'd given prior inconsistent testimony.
To give prior inconsistent, every witness in this trial, every one of those neighbors gave prior inconsistent.
I'm not going to argue about it.
But well, I don't think there's a basis for him to treat her as an adverse witness here.
All right. What else?
And in terms of him being able to raise the perjury question and essentially threaten her that if you're not telling the truth, and make those insinuations on this other subject on which there's no evidence of her falsely testifying, and now he's bullying her into saying she's not sure about something that the evidence is abundantly clear that she wasn't wrong about. It didn't happen in 1998. But I think the prejudice from him being allowed to improperly treat her as an adverse witness, to bully her through threats about following the oath and perjury, and by switching prosecutor, all those things I think have been prejudicial and denied Mr. Jensen a fair trial. And I move for mistrial on those grounds.
Well, and I would point out that the latter of those statements, those objections that you make, are as far as his. You say bullying her. I'm not sure I would use that terminology. In fact, I'm sure I wouldn't. And as far as the court accepting the proposition that she was a hostile witness, are all resultant from the fact that at the examination at the forfeiture hearing, she was asked not about sexual intercourse, which I don't think people can be held accountable for our legal language that includes where fellatio and cunnilingus are part of sexual intercourse, but she was asked about sexual relations, and she was either fencing with the district attorney or willfully distorting the facts. And then she talked with her lawyer, and she changed her testimony. So those are adequate reasons for what happened.
She corrected it on her own.
Well, you can have your own interpretation, but that explains why I've done what I've done. Anything else?
well, Your Honor.
Yeah, I guess we got to get into the thing that brought us in here.
Yes.
The other men. Well, go ahead.
Well, Your Honor, it was my intention to have this witness identify each one of these pages, I don't know that we'll necessarily mention each of these guys by name, but we're going to have, I'm going to ask her about the specifics of what is discussed here, because I think that goes right to the ability of this witness to actually recall the circumstances of this conversation, because my guess is the first time she had this conversation with Mark Jensen, she'd never had a conversation like that with any other person in her life before. And considering the unique, and we'd even say bizarre nature of the inquiries, of the information that she was providing, I mean, I don't believe her when she says she doesn't remember. She knows when it happened. And I think that I'm entitled to cross-examine her on that issue about the precise and specific nature of these conversations. And I'm going to ask her if she knew that Mark Jensen was taking notes at the time. And my guess is she probably wouldn't have engaged in this conversation with him if she'd have known he was taking notes regarding each and every salacious detail of each and every one of her previous lovers' relationships. I don't believe that any woman would do that. I don't believe this woman would have done that. But certainly to suggest now, as she has here, I'm entitled now to present to the jury the nature of this conversation so the jury can then decide for themselves, gee, is Mrs. Jensen telling the truth when she testified that she didn't really remember when this conversation occurred, but she just happened to testify on direct and then on a cross-examination for the defense, just happened to testify, this conversation occurred in 1999. It occurred sometime after after 1998, which just happens to be consistent with what her husband told her to say. So it's implausible, Your Honor. It's especially implausible when the jury hears what's on these notes.
The specifics involving what's in these notes have no value whatsoever except for them to try to tarnish Mr. Jensen and have this court decide, have this jury decide this case on something other than what the issue is. When I say that's the only value, I mean these notes again. When the note is on a June 13th, 2000 calendar, well, it suggests that maybe that's the timing that it happened in. I think this witness absolutely was honest, and we have pages and pages of internet chats, and she explained that couldn't have happened before 1999, and that's why she has a good faith basis. But how it would matter if they want to introduce what she has to say about 20 other men, how is that possibly relevant for any purpose other than them to try to cast aspersions at Mr. Jensen and say he's odd about this, as Dr. Kinsey Jamboys has had to say. I mean, we don't
call names, Mr.
I'm not calling it.
I take it as a compliment. I'm not offended.
I'm not calling a name because I'm just saying Dr. Kinsey because he's suggesting some sort of.
I don't share your view as to the purpose. The fact that it may paint the defendant as having some fetishes and things like that is really secondary. And that's why I originally, at the motion in limine, said I wasn't going to let it in. But yeah, I think that the district attorney is quite right that this kind of a discussion, one would think, at least for most folks, would be recollected with great ease.
Well, that's
because I would consider this to be a very unusual conversation.
Well, that was my Dr. Kinsey reference because I think Dr. Kinsey exposed all sorts of things that people do that to them are not unusual that other people think are.
Well, we'll find out what the good people of Walworth County think.
Well, the problem is if I'm right about that, is people think what other people do is unusual, and they want to. There's a risk of them penalizing Mr. Jensen for sexual issues and not giving him a fair trial in this case.
That's why I originally said it couldn't come in. But as I say, that the excessive dependence on motions in limine, I think, causes just these kind of things to erupt. I do want you to respond to his one observation about the one note being on a 2000 dated stationery.
I don't know what he's talking about. It's not one of these notes.
That's what I wanted.
It's not one of these notes. I've got the notes here. I'll show them to you. Let me look at them first.
I never saw it before. Or I take that back. I don't recall ever seeing it before.
You see, Your Honor, in 2004, there was a stack of documents obtained from the Stiefel Nicholas offices that because Mark Jensen had left the firm in 2002. And in 2004, we executed a search warrant.
I know
We
that.
obtained a stack of documents.
I have
But
been on this case almost as long as you have.
I know you have,
So,
Your Honor. But now, here's the thing. I'll show you these exhibits, 149 through 159.
Why don't you show them all the stuff that was
Give us a hint.
collected instead?
No, I'm going to show them what I want.
What? Just a minute. Where's the document with the 2000 date on it? Has this ever been presented in court before?
Not that I know
No,
of.
the
I've never
prosecutor has chosen not to present that, but it was in the materials that I received along, and I presume Detective Ratsberg has the originals of these. There's also a 2000-2001 calendar page among those materials, and many chat room
Can I see that?
transcripts.
Can I see that document? I don't recall ever
Well, he
seeing it.
does make some girth references.
Well, what's the copyright date on the bottom of that document?
1998.
Yeah, what's the copyright on the bottom of this document?
Those are blank pages that they don't have to change year after year. But this proves that that your copyright theory doesn't work anyway.
Well,
Your Honor, here's the documents that the state intends to introduce. It's exhibits 149 through 159.
some of which, 157, 158, and 159 are on different type of paper, the 1997 Franklin Covey Company's paper.
Correct. I think, Your Honor, what happened is that and I think the inference is that Mr. Jensen started out on this examination when he was examining his girlfriend about previous sexual relations. He started out on this notepad and ran out of room on it, so he started writing it on pieces of paper, which is a reasonable inference.
So how do you explain the year 2000 entries?
That wasn't from those set of documents, Your Honor. That was in the stack of documents, the foot-and-a-half high stack of documents that was obtained under the search warrant. That was a collection of documents that were left behind in Mark Jensen's office when he left. That was in that stack, and there's no indication that we're close to that stack.
Let's put an exhibit mark on this, just so the record is clear what we're talking about.
Judge, I took the pages that I received from the prosecution and I bait stamped them in the order that I received them. And all these are basically next to each other. The other thing is, I think that this witness should not be
I
testifying.
mean, basically next to each other.
What are the base stamps?
What is basically next to each other? Is that different from next to each other?
I got the stack, I gave them to my secretary, she bait stamped them.
Okay,
Well, are they sequentially numbered?
That is fully my belief. I didn't bait stamp them, but I gave.
Well, this one doesn't have a bait stamp.
because that's the
157 doesn't have a, oh, I see, okay.
That's our-
What's your bait stamp on your copy of Exhibit 157? And the other thing is, it's this one here.
Yeah, it's,
Other side.
the flip side of 255.
This is 233, 165.
And it's 233. And it's all the same type of
Well,
materials.
the other thing is, they may have just been stored together, I don't know. I would tell you that one would not expect, Mr. Albee, a person who would ask these kind of questions of a female to only do that once in his life. I think to the reason it was kept out, it was because it was suggestive of fetish by the accused. And a fetish, I think, by definition, well, maybe I'm no psychologist or psychiatrist, but I think it's something that occurs persistently. So the fact that there may be notes about people's anatomy that may have been made on different dates and are stored together doesn't prove that they were made at the same time, and especially when the district attorney, I think, points out that they do have different years on the copyright.
Judge, there's a planner that has separate pages that you keep in the planner that are just...
Don't talk, if you've got the planner, I'll look at it. I don't want to hear your hearsay account about how Franklin Covey does their planners.
Well, you can, I think the court can see from that there are pages that don't have dates.
Sure.
And
Your Honor, I guess I object to any further discussion
This is
about this
gonna be-
in front of the witness and
Look, what? No, there's the further discussion is going to be my stating that unless you have someone from the company come in here and tell me this is how they do it, I'm not going to accept. You may make it as an argument to the jury that doesn't that make sense to you, but you're asking me to premise a ruling and slam the door on evidence based upon it. I'm not going to do it.
well, two things. I don't know why the burden is on the defense to show the Franklin Covey company and to establish that the burden, I think.
Because you're trying to suppress evidence.
Appropriately, it was on the state. No, the proponent has the burden of establishing the admissibility.
And they've told me that one has a 97 copyright and one has a 98 copyright. And you're giving me an explanation why that's hearsay.
Well, what I'm saying is what's apparent is that some of them have dates and other ones are blank pages, and that's why they have different dates on them.
I understand what you're arguing.
Here's the other thing, Judge. Detective Ratsberg took Mr. Jensen's planner on December 3rd, 1998. These notes weren't in it.
I don't know where one would store notes like this. I'll tell you what, if I'd made notes like this, I sure as heck wouldn't put them in readily accessible areas. All right. So I'm going to allow the examination.
so how long recess before bringing the jury back in, Your Honor?
How about 5 minutes?
Okay.
Is that enough? Okay.
Your Honor, request that Mr. Albee be instructed not to speak with a witness.
Any objection?
So it's clear as to this issue of introducing these documents relating to discussions between Mrs. Jensen and Mr. Jensen regarding her past sexual partners. I object on 90404 sub 2 grounds, 90404 sub 3, and also I don't think Mr. Jensen's constitutional right to due process, and in particular his right to a fair trial. I believe that there's an intolerable risk here that this evidence will be used as improper character evidence to suggest that because Mr. Jensen has what at least some people might view as unusual attitudes about sex or unusual attitudes about sex, that he would be such a type of person that could kill his wife, and I expect that the prosecution will attempt to have the jury draw that kind of conclusion. I don't think there's any reason at all for trotting out the particular details of these relationships and the conversations between Mr. Jensen and his now wife. Also, if the motion in limine had not been granted and I knew this was all coming in, I would have handled jury selection and opening statements different by confronting these things head on during both jury selection and opening statement. And last, I think that just as with Dr. Long, where we took evidence outside the presence of the jury to see what would be said, that would be an appropriate way to proceed with Mrs. Jensen. But for all those reasons, I believe that this evidence should not come in and that it violates Mr. Jensen's constitutional right to a fair trial and due process.
Did you want to respond in the same
Briefly.
length of 25 seconds?
Briefly, Your Honor. The reason that the court granted the motion in limine before this trial ever commenced is because you determined that the unfair prejudicial effect substantially outweighed the probative value of the evidence. And, you know, I won't say that was a correct or incorrect assessment, but certainly now, the probative value of this evidence is far, far greater than it otherwise would have been. None of us had any reason to believe before this trial started that the witness was going to be untruthful about the circumstances surrounding this conversation. And yet, I think there's a fair inference, an almost unavoidable inference, that in fact she has been untruthful about it. And now she's coming around closer to the truth, and it was only after she'd been reminded of perjury. And in both instances, Your Honor, in both the last hearing and in this hearing, it's only after this witness is reminded of the penalties of perjury that she starts coming around to start telling the truth. It's unbelievable that this witness does not remember this conversation precisely when this conversation occurred in view of the matters that are being discussed in this conversation. And counsel underestimates me. I'm not going to be arguing to the jury, oh, Mark Jensen is a sexual pervert. In fact, there's really nothing in this record. First of all, it pertains to Mrs. Jensen's prior sexual partners. And there's some people who had more prior sexual partners than she, and some people who had less. But it's very unusual, and I'm not going to seek to unnecessarily embarrass Mrs. Jensen. But the fact of the matter is, in order to get at the truth here, the circumstances surrounding these conversations have to be recounted so that the jury can understand that she's probably not telling the truth when she says she didn't really remember when this conversation occurred. That's what the purpose of this is, Your Honor. And it's for that purpose alone, and the probative value of this testimony is now far, far, far greater than it was, and than you ever reasonably would be at the time that you made your ruling on the motion in limine.
All right, and I agree with what Mr. Jambois has stated, that at this point, the value to the jury in making a credibility assessment and determining motivation and ultimately whether or not has been an effort by the defendant to suborn the witness substantially outweighs any prejudicial impact. And if you want, I will give a cautionary instruction to the jury about the use to which this evidence may be put. But frankly, I don't see it as by or bad acts of the defendant, so...
Well, yeah, because it's going to be his asking about it or having...
I suppose, all right, it's a distasteful act, I suppose, in the sense that it's suggestive of a fetish behavior. So if you wanted a cautionary instruction, I will give one.
What does the court have in mind, some instruction on?
I'm just saying that you're going to, when the evidence starts to come in, I'll interrupt or at some point in conjunction with the testimony, I will give an instruction to the effect that the evidence that they are hearing or have heard relates to conduct for which the defendant is not now on trial, and it is being offered by the state for the purpose of suggesting that the witness may have a greater ability to recall because of
I wouldn't put it like that, Judge.
No, I wouldn't either.
And here's how I would suggest you put it. There's a specific criminal jury instruction that relates to the admission of other acts evidence. I would suggest you read exactly what's in that jury instruction.
Which of the categories would you suggest?
I don't have the instruction in front of me, and I don't have Mr. Albee's prodigious memory, so I don't.
Do you have a suggestion, Mr. Albee?
Well, no, I was asking if there's some suggestion because I frankly think my recollection of the pattern instruction, I don't know if the court has it available, is that it will unduly emphasize.
Do you remember the number? Is that 240 or something?
I don't recall.
I'm going to hazard a guess.
Let's have a look. It's a little longer because I'm out of county. Contents. 275. Let's have a look at it. Evidence has been presented regarding other conduct of the defendant for which he is not now on trial. Specifically, evidence has been presented that the defendant interrogated Mrs. Jensen.
Question.
All right, question Mrs.
Well, question-
Jensen about prior sexual experiences which she had had. If you find that this conduct did occur, you should consider it only on the issue of her credibility. You may not consider this evidence to conclude that the defendant has a certain character or a certain character trait, and that the defendant acted in conformity with that trait or character with respect to the offense charged in this case.
I would object to the instruction being read like that, Your Honor.
Why?
Because it's not being offered only to establish her recollection, but also to establish that the defendant was getting her to alter her story, and he was coaching her about what to say. He coached her over the telephone to say that that never happened. We never had that conversation in 1998.
No, Judge, I don't want any instruction. The notion that the court's instruction would give an imprimatur to this theory of the prosecution, I don't want any instruction at all, because it's more prejudicial to suggest through a court instruction that there's any basis to this theory. So I don't want an instruction.
I think it only indirectly is probative on the issue of whether or not the defendant suborned perjury, and therefore that it's evidence of concealment.
But if he doesn't want an instruction, Your Honor,
But,
you're not going to give an instruction if the defense counsel doesn't want an instruction.
well, do you want an instruction or not?
No.
No instruction at all?
No, because
Okay.
any instruction, Mr. Jensen's prejudiced by the admission of this material, but he'd be more prejudiced by an instruction, given that we're still talking about all this, basically the last 4 hours of court time has been spent because of this phone call of a few seconds where he just tells his wife what happened in court and says that didn't happen in 1998, and there is no evidence of it being coached, and that's exactly what I was talking about needless consumption of time, and all of it far outweighing the probative value. And,
All right, your objection's in the record, and you've requested no instruction. So none will be given. All right, let's return to work.